Thank you, Mr. Speaker.
On debate, Senator Joyal.
Let me say at the outset that I support the objective of this bill, as both Senator Black and Senator Ouzakos has been explaining to us. Nobody would question the merit of the bill in terms of the celerity of the admission to U.S. or the moving of goods through borders. I would like, honorable senators, to remind you one thing. When Parliament adopted the Charter of Rights and Freedoms in 1982, and I quote the Supreme Court Justice Dixon in 1986, our system of government was transformed for one of parliamentary supremacy to one of constitutional democracy. What does it mean? It means essentially that the government is not supreme, nor Parliament is supreme. Both of them are bound by the Charter of Rights and Freedoms and by the respect of those rights that have been entrenched in the Constitution of Canada. So when we approach a bill such as this one, which has been the object, as Senator Ouzakos and Black have mentioned, the object of extensive negotiations between the two governments, we still have to consider the impact of the result of that negotiation to the, I should say, to the measures of their impacts in the rights and freedoms of Canadians. Let me remind you one example. When the Canadian government signed an agreement with U.S. to exchange information about some Canadians who might be suspected of terrorism, nevertheless, the Canadian government remained responsible of the information that they provide to a foreign country, i.e. United States, the use that United States might make of those informations, and the treatment that is given to Canadians who happens to be on American soil or foreign soil on the basis of the information that has been transferred. I don't need, of course, to remind you the Mayer case, the lengthy investigation and the fallout of the conclusion of that inquiry and the compensation that was paid to that Canadian, essentially on the basis of the use of information that was transferred by the Canadian government to a foreign country and the way they use it. So it seems to me that when we look into an agreement like this one, which is, as I say, nobody would deny the benefit of it, as I say, for the celerity of the passenger treatments of Canadians crossing the border or the goods moving to United States. Every one of us will agree with this. And I'm the first one to support it. In principle, I crossed myself the border, ample times, many times over a year period. But it doesn't prevent us from testing this bill at the measure of the rights and freedoms that Canadian enjoys. The Canadian government doesn't have the capacity to negotiate or barter the rights and freedoms of Canadians for the benefit of celerity, and agreed on all kinds of conditions that we find in this bill that, in my opinion, are problematic. And I will mention to you, honorable senators, 3 sections where I feel this bill is still problematic, and those concerns have been outlined last Monday, and I read through the minutes of the committee. I raised them at second reading, and they were amply, I should say, explained by the Canadian Bar, by the Quebec Bar, by the Privacy Commissioner, by the Canadian Muslim Association, by the International Civil Liberties Group, and by the BC Civil Liberty Association, all of whom testify in front of the committee. I'm looking at Senator McIntyre. I think you were attending in there, and I read the question that you asked to some of those witnesses, and I was enlightened by the answer that the question that were asked by our colleagues and the answer that we got. And I still feel that there are 3 sections of the Charter that makes this bill problematic. The first section of the Charter is Section 8, and I read it. Everyone has the right to be secure against unreasonable search or seizure. The Bill 23 contains a Section 22, that allows strip search even though a Canadian officer has refused to perform it. I repeat, you are on Canadian territory, a Canadian officer refused to perform the strip search, nevertheless the American officer is entitled to perform it. Or he is entitled to perform it in the absence of a Canadian officer. That, to me, is a gross violation of Section 8 and is challengeable in any court of law, because strip search has been deemed by the Supreme Court as the most intrusive and the greatest violation of a Canadian dignity. There's ample jurisprudence on that, the last one being a decision in Ward against British Columbia in the city of British Columbia in 2010. So that section of the bill, in my opinion, is challengeable immediately for anyone who would be the object of such a search. Senator Black tells us, well, it never happened. Well, if it never happened, why would put it in the bill? If it never has happened, there's no need to give that power to the American officer if there's no risk of the risk has never happened in the past. The second section of the Charter that is problematic is Section 9 in this bill. Everyone has the right not to be arbitrarily detained or imprisoned. And Section 10, everyone has the right on arrest or detention to be informed, to have a lawyer. We all know, the criminal code protection in relation to somebody who is arrested or detained. Well, the bill, unfortunately, when a Canadian passenger decides to withdraw from clearance, could be detained at the will of the officer without the criteria of reasonableness that Senator Black has mentioned, with absolutely no reasonable ground to believe that that person, is in the process of committing a crime or is part of a network of terrorists or is trying to move goods illegally in the state. The American officer can detain immediately a person who decides to withdraw. And honorable senators, we don't have yet Bill 45 in this chamber, but think 2 seconds of a Canadian citizen who is allowed to have cannabis in his pocket or in his knapsack, goes to pre-clearance, realizes suddenly that he has 2 joints that he is not allowed to take in the United States, decide to withdraw. He could immediately be detained and go through all the process that is provided in Section 29. So in other words, we have to be very mindful that this bill contains a section that will be very problematic if Bill C-45 is adopted and become law. And the third section of this bill, which is still problematic, is Section 24. And Section 24 of this bill allows any Canadians whose violation of rights any Canadian whose right has been violated, and I read it, may apply to a court of competent jurisdiction to obtain such remedy. Well, the Canadian government has been very wise in negotiating that agreement and adding something that the American did not request, which is to absolve Canadian officer and Canadian government of any responsibility. So the American didn't ask the Canadian government to absolve themselves of responsibility. But the government put that section in the bill, and that's why, honorable senators, on those 3 counts of Section 22, 29, and 34 of the bill, I move that Bill C-23 be not read a 3rd time, but that it be amended, A, on page 10 in clause 22, by deleting line 8 to 19, B, on page 12 in clause 26.1, by replacing line 37 with the following, quote, in section 22, 23, 24, and 32, ends of quote. C, on page 14, I, in clause 22, by replacing line 1 to 3 with the following, quote, 29, subject to section 13 to 15 and 32, every traveler bound for the United States may withdraw from preclearance and leave a quote, and II by deleting clause 30, D on page 14 and 15 by deleting clause 31, E on page 16, I in clause 32 by replacing line 5 to 7 with the following, quote, 5 in section 25 and 26, end of quote, and II in clause 33 by replacing line 22 with the following, quote, paragraph 32(1)(b) to produce biometric, end of quote, and F on page 19 in clause 39 by deleting lines 18 to 20. I apologize, honorable senators, with all those calculations, because of course when you change one section you have to renumber and replace the paragraph and whatnot. So honorable senators, if the amendments can be circulated, I would appreciate that, so that honorable senators understand the point. I think that this is a very important bill because it trades the rights of Canadians for a benefit that we all agree are desirable. Celerity of passengers, moving of goods is something that has to happen and be maintained between the borders. But it cannot be at the expense of Canadian rights to enjoy the protection of those rights of the Charter that has outlined and their capacity to seek redress if they are the object of violation in the context of the protection that they enjoy as Canadian. And don't forget, they are still on Canadian territory. We're still pre-clearance on Canadian territory. We're not dealing here with pre-clearance on American soil. This bill applies essentially on Canadian territory. How can the government negotiate with a foreign country lesser rights that Canadians enjoy in the Constitution? Honourable Senators, again, read the testimony of the Canadian Bar, of the International Civil Liberty Groups, of the BC Civil Liberties Association, and you will realize that there are very important issues, that are included in this bill that needs to be addressed. And as again, Senator Black is saying, it's a deal. Take it or leave it. Because if you don't accept the way that this bill is packaged and negotiated, forget it. I don't think it works that way, honorable senators. I think that there is a provision in this bill that allows the Canadian government to raise issues and to transfer to and express and negotiate with the American citizens, with the American government, the obligation and responsibility that binds the Canadian government. And I'm quite sure that the amendments that we're requesting are not amendments that endanger the substance of the bill, that will make it more complex for the Americans, to perform their responsibility. As you have said yourself, those concerns are minor, to quote your own terms. So if they are minor, well, why can't fix it to avoid that this bill be the objects of challenge in court, of lengthy procedure, costly procedure, and finally compensation in the amount of money that we have had in the past years, following the experience we have had on other agreements that we have signed with foreign country that whereby the use of the information was done not in the context of the respect of the rights and freedoms that Canadians enjoy. So I feel very strongly about those, honourable senators, because my conviction on the basis of the testimony that the committee heard opened this bill, unfortunately, to very serious and lengthy challenge. And I think it is our responsibility in this chamber to put them on the table and to see how we can improve the bill essentially in the context of respecting the rights and freedoms. I'm not asking any more thing than we making sure that we are not for the overall objective of the good, that in fact we are creating some problems that will come to haunt us one day, especially, and I don't want to threaten you about this, but I want just to alert you that when C-45 is adopted, believe me, the extreme vetting at the border that the present American government wants to perform, especially if you're a youngster, with a long hair and, the look that I'm thinking about, you're immediately suspected that you might carry a substance that in the eyes of the American government is illegal and that you're not allowed, to take to United States. So this is a very immediate, serious issue. I'm not dreaming about those. I read the report that former Minister of Justice McClellan tabled on the cannabis legalization, and nobody was able to answer in the other place when that question was put to them. So let's, honorable senators, make sure that this bill is charter-proof, to make sure that we're not finding ourselves in nightmare the 2nd of July or the 1st of July when those youngsters will flock through customs. Thank you, honorable senator.
Sorry, Senator.